New developments in the fatal shooting of a Kentucky judge are what's trending this morning in true crime, as recordings could tie the slain judge to a sex for favor scandal. Audio recordings were obtained by NewsNation from a criminal investigation into a Letcher County deputy sheriff in an unrelated case. Sabrina Atkins is alleged to be a victim in that case, and she's the woman who's heard speaking to investigators while claiming that Judge Kevin Mullins was one part of a scheme to exchange sex for special treatment.
He does have some videotapes of some stuff in the judge's chambers.
What kind of stuff?
Just with girls' sexual and stuff.
What describe? Have you seen the videos?
I've seen one partly, just him having sex with girls for the able to get out of jail.
Who was having sex?
Ben and just some higher ups up there.
Who?
The judge and.
You saw the video?
Yeah.
What did you see on the video? I mean,
I've seen Judge Mullins having sex with a girl.
Who was the girl?
I don't know. Because I don't know a lot of people from over there.
Where was it at?
In his office, in the judge's chambers.
Is that the same place that you were meeting Ben? Is that how you know it was the judge's chambers? And this was Judge who?
Mullins.
Now, the motive and the circumstances behind Mullins' death remain unclear this morning, but we're asking, how could the sex for favors accusation affect the sheriff's trial? Let's bring in our power panel. Still with me, prosecuting attorney Anton Bell, retired criminal defense attorney Kirk Nurmi, and want to welcome in private investigator, a retired Army Special Forces member, former NYPD officer Manuel Gomez. Manuel, would like to begin with you, please. Would you start off our conversation? Your thoughts on how these accusations could potentially affect the sheriff's upcoming trial?
Well, I think that these accusations are going to destroy his case, because the fact is that it actually gives a motive for him to shoot the judge. It's clear to me that the sheriff was acting in cohorts with the judge to facilitate this sex for bail and the sex for to be let out of jail or to not wear an ankle bracelet. And this case is so disturbing because it just shows how weak the judicial system is. Where do people like this woman, who was a victim, go to report the crime when you have a sheriff's department and the judge's department corrupt? And this is why this case screams why we need an independent agency. We should not have no judicial branch governing itself. You can't check yourself, monitor yourself, investigate yourself, judge yourself, and punish yourself. We need an independent agency, and this case screams why we have to have one.
I hear you, Manuel. Anton Bell, let me go to you next, please. Something that seems to be tricky about this, and this is like the kind of the big pink elephant in the room, so to speak, with this one, is that the sheriff's minor daughter has been mentioned as being some component to this. Investigators, prosecutors have not pinpointed exactly what role she plays in this big overall story, but we do know that we heard some things at the preliminary hearing about her contact information being in the judge's phone, the sheriff taking the judge's phone, being able to contact his daughter. We know that the attorneys have come right out and said, we're not denying this shooting. Yes, he shot him, but that this was a heat of passion crime, that this was his friend. Something came up. As a prosecutor, if you have a minor who may, and I'm saying may because we don't know if the sheriff's daughter is a victim in any way. We don't know. We don't have confirmation. If you do have a minor victim who is part of a story like this and a case like this, what things do you have to do as a prosecutor to safeguard that person's identity and also protect your prosecution and the integrity of it, Anton?
So whenever we are dealing with minors, and I have prosecuted many cases involving minors. Whenever we deal with a minor as a victim or a witness, we typically will use initials in any pleading, such as a motion or an indictment or even a warrant, we will make sure we will use some level of anonymity to make sure that we protect them. In addition to that, even if they are to testify, depending on their age in Virginia, we can actually have them do a two-way camera system where they will testify outside the presence of the jury and outside the presence of the defendant, so that it would reduce the intimidating factor or reduce the fear factor involved. However, in this particular case, it appears that there may have been some relationship between that judge and his daughter, which would explain why they're saying it was heat of passion, because they were supposed to be friends. They frequently ate lunch together. In fact, one article mentioned even the type of food that they would eat. So, and this sheriff used to be the judge's bailiff. So they had a long-term relationship, and it seemed like it was a personal relationship. So for him to shoot his friend, clearly something very intimate and very personal to him occurred. He found out some information, and clearly he retaliated based on that information, and he's probably not sharing because it is very close and dear to his heart.
Anton, thank you for that analysis. That's exactly, I think, where everybody's minds are going with these new allegations from this woman. You have to wonder, who is the girl? We don't know. Could it be the minor daughter whose name has come up? Again, we don't know, but of course that is a valid question in this whole legal case. Kirk Nurmi, let me go to you, please. With this new component, when you hear that audio recording from that woman, she very clearly states a girl, says she sees the sheriff having sex with a girl, doesn't say a woman. She talks about female defendants and cases, and then says, I don't know who this girl was. Tell me, do you think in any way this could help the sheriff's case?
You know, it's possible. It depends on how the prosecutor looks at this, because really we think about this case and you think about, oh, this idea of manslaughter, this heat of passion, but it was also very a calculated kind of execution, right? It might have been motivated by passion. And here we have a police officer who is enforcing justice on his own, right? His sense of justice, which is kind of very antithetical to what our justice system stands for. So the prosecutor could look at it that way, or he could be empathetic to the sheriff. But really, when you're representing someone like the sheriff, you're going to want to collect all that information and really draw that correlation, so you hope the jury maybe will see things a different way here. But really, this sheriff's actions, even if it was his daughter, if I'm the prosecutor, I'm looking at this, he robbed his daughter of the chance to have the cathartic effect of testifying in court, which we just talked about, as well as having him in her life. So, you know, this is, to me, as I'm the prosecutor, I'm looking at this as kind of as a horrible crime, as an execution, and I'm punishing the sheriffs to the fullest extent of the law.
I really appreciate that, Kirk. Anton Bell, I want to end the segment with some more comments from you, if I may, please. I know we're going to have to let you go and get off to court. Many people are talking about how investigators are being really tight-lipped in this one. We saw it in the prelim. I mean, the state called one witness. They did just what they had to do to get this case bound over and no more. And we know that there is so much discussion, so much curiosity with what in the world would cause this. Would you mind speaking to how the media plays in and the differences in how prosecutors can handle their case versus how a defense attorney, especially a private criminal defense attorney, could handle their case when it comes to talking with the media?
So when you are a prosecutor, you are limited as to what you can share concerning the case, because you have a duty not to prejudice any potential trial of the fact, and that is potential jurors. So as a result of that, the ethics rule limits what type of pretrial statements that a prosecutor can make. The defense attorney can say whatever for the most part. They're very open because it's their client. However, prosecutors are very limited into what they can say to make sure we do not prejudice any potential juror pool.
Exactly, exactly. Different ethical considerations, different rules that prosecutors like you must follow, Anton. I think that's something that's really not made clear often enough, and I'm so glad that we could end the segment with that today. So we'll see if we hear anything from the Sheriff's Council, and we don't expect to hear anything from prosecutors on this.